February the 9th at 1:30.
Like, I already got meetings and everything. The only thing I took money for was pot.
All right. Listen, we're gonna deal with this on Tuesday, February 9th at 1:30.
All right, thank you.
All right, I've got Pulaski County on here. Looks like Pulaski County is where Mr. Strunk is. Yes. Yes.
It is, Judge. He's my case. We've got
Yes.
an agreement worked out on this.
I do not. Tell her to put we try to do about 10 or something and then, but hold on, here's the thing. While they go to do their 2:30, we're all gonna be sitting here doing nothing. I'd rather somebody else be doing nothing than me doing nothing. All right, Mr. Berry, go ahead, please. Oh yeah, I've got it right here.
Okay.
Mr. Strunk,
Sir.
hear me?
Yes, sir. I'm here.
All right. Mr. Berry says you all have an agreement, correct?
That's correct.
Are you ready to go through with that today?
Yes, sir. I was going to see if would there be any way of dropping the court costs, though? Is it that possibility?
Oh, yeah. Yeah. We'll talk about that in a minute, okay?
Okay. Yes, sir.
No problem. Can you raise your right hand? Do you swear or affirm that you'll tell me the truth, so help you God?
I do.
All right, thank you. Mr. Strunk, first off here, let's look at this document right here. I don't know if you can.
I can't really read it or nothing.
Yeah, I know. I'm going to show it to you, but I've got to get this pulled up. All right. See this
Okay.
document?
Yeah, I do.
It's a motion to enter a guilty plea. Do you remember going over that?
Yes, Your Honor.
Is that your signature?
Yes, Your Honor.
Okay. This is the Commonwealth's offer on a guilty plea.
Yes, Your Honor.
That look familiar?
Yes, Your Honor.
And is that your signature?
Yes, Your Honor.
Very good. Did you read those both before you signed them?
Yes.
All right. Are you comfortable that you understand what you have signed?
Yes, Your Honor.
All right. Mr. Strunk, do you believe that you are being forced to enter a guilty plea against your will?
No.
Are you in fact telling me here today that you have reached this agreement voluntarily and you're prepared to go forward with pleading guilty?
Yes, I am.
All right. Mr. Strunk, do you understand that you have the right to remain silent, the right to have a trial by jury where the burden of proof is on the Commonwealth to prove guilt beyond a reasonable doubt, the right to confront and cross-examine the people that give evidence against you, the right to put on evidence in your own defense, and the right to appeal?
Yes, I do.
All right. Do you understand that if you plead guilty, you're going to be waiving each of those rights?
Yes, I do.
All right. Mr. Strunk, do you feel like you're under the influence today?
No, Your Honor.
Do you feel like your judgment is impaired today for any reason?
No, Your Honor.
All right. Have you had all the time that you wish to have to discuss this matter with your attorney?
I have.
All right. In this case, the Commonwealth appears to be making the following recommendations as to count 1, criminal possession, forged instrument, second degree. That is a Class D felony. The Commonwealth is recommending on a plea of guilty a sentence of 3 years. As to count 2, persistent felony offender in the second degree, the Commonwealth is agreeing to a dismissal of that sentence enhancement. Therefore, the recommendation would be 3 years. It would be consecutive to any prior sentence that you may have, and the Commonwealth is opposing probation. Do you understand all of those aspects of the agreement?
Yes, Your Honor.
Okay. Has anybody told you that you would get probation?
No.
Okay. Mr. Strunk, other than what we have just talked about, have you been promised anything else to try to get you to plead guilty?
No.
Are you pleading guilty today voluntarily and of your own free will?
Yes, Your Honor.
Are you acknowledging to me that on or about February the 12th, in the year 2020 in Barron County, Kentucky. You committed the offense of criminal possession of a forged instrument in the second degree when you possessed or passed a forged check in the amount of $3,769.14 drawn on another's account with knowledge that that instrument had been forged and with the intent to defraud, deceive, or injure another.
Yes, Your Honor.
Okay. Mr. Strunk, excuse me. I'm going to accept your plea of guilty as having been made freely, knowingly, intelligently, and voluntarily. Do you wish to be sentenced today, or do you wish to have a PSI and get sentenced at a later date?
I'd rather go ahead and get sentenced today.
All right. Mr. Berry, does that work for you?
That's fine, Judge.
All right. So, Mr. Strunk, here's where your request comes in. All right, I'm going to go ahead and impose your sentence today that you agreed to based upon the recommendation of the Commonwealth. That's a 3-year sentence consecutive to the other case, because I anticipate you will be in custody for the immediately foreseeable future. I will waive your fine and your court costs on the basis of indigent circumstance. I don't think it's reasonable to expect you to pay that while you're in custody. Okay?
Yes, Your Honor.
All right. So that's going to take care of that. Do you have any questions?
No, Your Honor, I don't.
All right. Then we will wrap it up here, and I'll get all of that paperwork done. Good luck to you. Okay?
Thank you.
All right. I believe that's it. I don't believe I have anything else over there, do I?
No, that was the only one here, Judge.
Thank you.
Thank you.
All right. Let's see, we can turn our attention to Hart County, try to get those folks worked out. Looks like maybe I've got, I can't tell who is that. Is that Miss South?
Yes, sir.
Okay.
That's mine, Judge. I filed the motion to, I don't have it in front of me. I think it was a motion to revoke probation.
Yeah, that's what it looks like. Let's see, Mr. Berry, I'll have to make sure she's represented by someone. And if you all want, we can go ahead and set this for next Tuesday
Fine.
at 1:30. Is that going to work for our friends in Hart County Jail?
I believe so.
Okay. We'll send you the info, sometime between now and then. And then if you have a problem, just please let us know, okay?
Thank you.
All right, so that's 2/9, 1:30. Mr. Berry, will this be you?
Do what, Judge? I'm sorry. I guess
Will this be you on Miss Beth?
that's fine. Yeah,
All right, fair enough. Looks like we also have over there Mr. Horton.
We're done.
Thank you.
Judge, this is my motion to revoke. Filed a motion, I believe, earlier in January, and then I filed a supplement to that last week.
Yes, ma'am. I believe that we are probably going to just need to set this for hearing. I think this is, Mr. Berry, I think you all also have this one to, DPA will have this one. So hearing 2/9. We're gonna be a lot of them. All right, so we will we will put that, we'll hear the evidence on February 9th at 1:30. Okay?
I'm trying to think if I think I represented Robert, if I'm not mistaken.
Somebody in the office over there did, but I can't remember which one of you guys it was.
It was Josh originally.
Oh, okay. Okay. Then Josh will have the hearing on that then.
All right. All right, Josh.
All right.
Okay, Mr. Horton, we'll see you next Tuesday. Joshua Bunch. Hello, Mr. Bunch.
How you doing?
I'm doing all right. What we have you on here for here today is an arraignment on an indictment that was issued back in October. Do you want me to explain your rights to you?
No, sir, I know.
All right. Mr. Bunch, this indictment charges you with fleeing or evading in the first degree, which is a Class D felony, driving on a suspended license, speeding 26 or more, over reckless driving, and PFO. Do you want any more information about the indictment?
No, sir.
All right. What address would you be at if you were not in custody?
200 Apartment D, Shamrock, Glasgow, Kentucky, 42141.
Say that again.
200 Apartment D, 2 Shamrock, Glasgow, 420 zip code.
I can't tell if you're saying B as in bear or D as in, you know,
Yeah. D is in dog.
dog. There you go.
Yeah.
Glad you could think of something.
All right.
Are you in jail because you got arrested for this indictment, or are you in jail for something else?
Same charges, one crime spree. I just crossed county line in Hart County. I thought y'all was gonna run together. They didn't offer me 2 years here. Then, we shot them, which shot Barron County a counter offer for 3, and they didn't want to do it. They want to go 4. I don't understand why. It ain't like I went on a multiple crime spree. It just,
Yeah. All right. Hold on a minute.
all right.
This is a pretrial conference. In October.
Judge, it looks like he goes back to his Hart County on that February 16th is his next court date over there in 20 CR 199.
Yeah, I was laboring
He's
under.
got $9,500.
I was arraigning him. I forgot we already arraigned him way back in October. There was just when I opened the file, there was an indictment sitting there, so I arraigned him again. He's already been arraigned. It's a pretrial conference. Says it right here on the docket, pretrial conference. So if you all, any of you tell me what you got in mind.
Judge, we don't have an agreement on this. Joshua kind of laid it out there, what we negotiated back and forth some on it, but we've not reached an agreement. I believe he has, I think he's entered a plea in Hart County already on his case up there.
Yes, sir.
So I believe that's his sentencing, must be set in February or later this month. I don't know, I don't know if we're going to get anywhere on on negotiating on this or not, Judge. I haven't been able to so far, so.
I did dismiss a PFO first degree, so.
So anyway, I don't know if another pretrial would help or just pick a trial date or what we'd need to do on it, Judge.
Well, yeah, I mean, let's set one more pretrial, and I guess let's, if he gets sentenced in Hart County and we know for sure what's going to happen over there, then
Okay.
maybe that'll help, maybe not. I mean, if we need to set it for trial, it doesn't matter if we wait 3 weeks and set it, I don't guess.
Okay,
I
So,
mean, it's done a lock deal that I took 2 years here just to run concurrent with Barron. Like I said, it's one crime spree. I'd be willing to take 3 and gain an extra year. You know, I got 15, so it's gonna put me at 18 years. It ain't like I'm walking home.
I don't see that I mean, considering the nature of the charges and that he has charges in 2 counties, and I think was on either probation or parole, I can't run that case concurrent with Hart County.
It's gross.
yeah, I mean, they make whatever offer they want to make, and you either take it or you don't. So I can't control what happens, whether they offer you something you want or whether you take something you ought to. I can't control either one of those. So let's come back. Amy, what day did you say he was going back in Hart County?
On February the 16th, Judge.
All right, so we'll put this on the 22nd.
Yes, sir.
All right, thank you.
All right, see you. All right, I believe that's got us squared away in Hart County.
Thank you, Your Honor.
Thank you. Bonnie, can you tell me who you brought in down there at Barron County?
I've got the first 10. It stops at Stanley Merle.
All right. So, folks, the way we're doing the Barron County detention is that they've got the first 10 of the inmates in there, and then they're going to have to stop and go back and finish up district court. They had a couple things in district court, and then they're going to come back on with everybody else. So, well, let's go ahead and get those people taken care of, and then we'll get the other folks that we have on here taken care of, and then we'll, hopefully it'll work out. So I would guess that means Amber Carver's in there.
Yes, Judge.
How you doing today?
Yeah, I'm doing all right. How are you?
Good.
Judge, I'm representing Amber. We don't have an agreement on, there's a motion to revoke bond, I think also that has been filed by the Commonwealth on some public intoxication charges that she's picked up. As far as her pretrial conference, we don't have an agreement worked out on that yet. Mr. Gardner sent me an offer and we talked about it some today. I didn't make a counter offer on it. I don't know if I'm to the point yet of making a counter offer on it. If Amber and I need to talk about it again to see if she agrees with me before I say anything back on it. Amber and I have talked about the case and in which way she wants to go on it, but we don't have a counter offer yet. And I don't know if Mr. Gardner meant to hear the bond revocation motion today, or he was just wanting to pick a date. It was set for today to it says to pick a date for a hearing. So she was assessed, Amber was assessed by our social worker last Friday. And she's trying to get her into it's not really long-term treatment. It's more like a 28-day type of treatment that she doesn't have it yet. She's not been able to come up with it this fast. So if we put her on for the 8th or the 9th, whichever date it is next week for hearings, we could do the bond hearing and I could have more information on the potential rehab and whether or not we have a counter offer on the case in chief.
Okay.
Your Honor, the Commonwealth has filed a motion to revoke her bond based upon those new 2 PI. Greg came out of the office this morning. We discussed this case briefly, and my main concern right now is that Amber, A, doesn't have a place to live, and then B, has picked up 2 public intoxication charges. I know she claims that she was knocked unconscious on the last one, maybe even for both of them. I can't remember what her story is, but it seems like A, she's homeless, B, she's in the throes of addiction. And if we can try to, treat both of those at this point, Commonwealth would be willing to do that. I would go along if she is able to get into a treatment program that in lieu of revoking her bond, that she enter and complete that.
Why don't we do this? I think it'll be easier probably to put this hearing on for Monday rather than Tuesday, just in light of the number of things that we've put on for Tuesday already. So why don't we put this on for 10 o'clock on Monday, and we can kind of go back, we can go over what Mr. Berry may have found out by then. And, I guess have your officers available if we need to have a hearing, but it seems like maybe if she gets, you all may be able to have it worked out by then. If not, we'll do whatever we need to. Okay.
Okay, Judge.
Does that make sense? So 2/8, February 8 at 10 a.m. Okay.
Okay, Judge.
All right. Ms. Carver, we'll see you then.
Okay,
What?
okay. Am I sitting in here or am I going out there?
You'll be in there probably. We're not having people up here.
Right.
Okay. Joshua Kogar.
Judge, Mr. Spears and we've been talking about Mr. Kogar. I think we're pretty close to resolving his cases. There was a question about, I guess, whether a plea agreement would affect, some classes he's taken at the jail. I've emailed Officer Alexander. He's looking into that for me. If we could put this off for 2 weeks, I'll have an answer, and then we can see if we can resolve it at that point.
Yeah. Okay. 15th.
That's fine.
All right, Mr. Kogar, hang in there. We're working on it.
All right, thank you very much.
Thank you, sir. Let's see. Mr. Berry, we have Mr. Creighton.
Okay, Judge.
24th. February.
Judge, I don't remember the last time we were had INL in here. I don't think we ever picked a trial date.
Yes, we did.
We did. We just aren't going to be able to do it because the Supreme Court has told us we can't try anything until after April.
Okay.
And his was set between now and April.
Okay.
So, and the reason that, I checked on it and saw that it was on for a pretrial, prior to the trial date that we had set. So I just left it on because I knew we were going to need to get a, look at another date.
Okay.
What we'll do is just, if everybody's prepared for me to go ahead and do that, I'll start looking.
That's fine, Judge.
Okay.
Yeah, the court's aware we mediated this case. We were nowhere close to getting an agreement. I don't think we're going to reach an agreement unless there's significant movement by the defendant. So it doesn't look like that's likely at this point. So
What would you all think about August 11, 12, and 13? I think we only had 3 days set aside for it to begin with. I guess possibly we could run into a problem getting, it might take longer to get a jury than we're expecting, but I could do it the next week and, and do it 4 days. We've got both weeks I've got trials already set, but this one would take precedence. If I had to bump one of those other ones, that's what I'll do, because he's in custody, of course, and one of them's a civil case and the other one's a criminal case, but the guy's out of custody.
Okay, Judge. Xanda, are you on here? You're not showing up on my screen. She's
Here.
gonna be working on the case with me. I just want to make sure is those
I'm
dates,
here.
okay, are those dates okay on your calendar?
Yeah, those are fine.
Okay.
Judge, oh, go ahead, Greg.
I was just saying, I'm fine with those dates.
The only issue I have is I've got a special prosecution case in Cumberland County that's supposed to start the next week, but considering how the trial calendar is going to be like, for everybody, I'm fine with going ahead and setting this. And if I got to try 2 back to back, I've got to do it. So.
Well, I feel like what I'm concerned about is that 3 days. I feel like we'd be smarter to do the 17th, 18th, 19th, and 20th, because I think it's just going to take extra time to get a jury compared to what we're accustomed to, based upon, not going to be able to get everybody in the room at one time, I don't think, to do it. We'll have to at least do it in 2 shifts rather than 1, which is going to take, you know what I mean.
Yeah.
That if it's a 3-hour process, it'll turn into a 5-hour process probably.
Right.
Or 6 hours, so that's a whole day by the time you get into all that.
Now that week I do have that special prosecution case we just set this within the last 2 weeks.
And it's what week?
It's at 17. It starts that Monday, actually.
Oh, okay.
16th, 17th. So.
I thought you were telling me it was the next week.
Well, it was the week following what you originally proposed.
Well, what if we moved it up and did the 3rd, 4th, 5th, and 6th of August? That's a civil trial again that I have. And so, if I have to bump it, I'll bump it. It's not got expert witness, it's not like a malpractice or anything where they've got a bunch of people that will just have fact witnesses.
Yeah, that would work better for my calendar, Judge.
What about that, Mr. Berry? And
I can do that, Judge.
okay. So that's August 3rd, 4th, 5th, and 6th. And then let's do one final pretrial. We'll do July 12th. Okay, thank you.
Mr. Berry, will you be up here to see me anytime soon?
Well, I can't say it'll be this week, but it'll be within the next 2 weeks, I know. Okay. You say July 12th, Judge, for the pretrial?
Yes, sir.
Okay.
Eric Denton. All right.
It's my mission, Judge. We just need to set a hearing date.
Okay, do you want to do next Tuesday?
That's fine with me.
Who will, let's see, Mr. Berry, I'll need to make sure that the last time I think we had anything actually happen in court, it might have been Tyler doing it.
Judge, I've taken over this case.
Okay, all right, all right. Good deal. So, hearing 2/9 at 1:30.
Is there any way we can do ankle monitor, Judge?
Sorry?
The district court said they do whatever you want to do as far as bond went. Could we do a ankle monitor or get assessed for rehab or something? I've never been offered rehab, drug court, anything like that.
Well, we'll have to wait and see what we
Because I think you got me on a no bond right now.
That's true. I mean, I'm not going to do anything before next Tuesday when we have this hearing. Then, we'll see what we find out. Okay?
As far as lowering the bond or what? Can I get assessed for rehab or anything?
Or as far as any of those things.
All righty.
Okay? James Depp.
You say 9:30 on 2921 for bidding?
Judge, I don't see Bruce Brown on here. Johnny's on here. Obviously, he represents him. The majority
Two of his cases, Judge.
Very good. Schedule. Yeah.
When it pleases the court.
I'm ready.
I talked to Mr. Depp, Judge, about this situation and cases. We have an offer right now. Mr. Depp has asked me to make a counter offer to the Commonwealth, which I'm in the process of doing. He has also brought up some issues concerning some possible motions due to some constitutional violations he feels. So I guess at this point, we'll try to get that done in the next couple of weeks and see where we're at. But right now, we don't have any resolution as far as the offer we've got now. I think he's on a 6-year sentence, and I believe we were offered 10 or 15 on the other. And that would put him up to a substantial amount of time at his age.
He also has a substantial amount of cases as well, so.
That's true too. I understand.
Well, how about I put it on for February 22nd? And if you're going to file something, you file it before then.
That's fine, Judge.
Make sure we get a copy of this to Mr. Brown, please.
John, I will send over a counter offer. I just, you can look at it, just let us know.
Yeah, I'll do that.
Thank
All
you.
right. Thank you.
You have a good day.
Ricky Hammer.
Judge, we have a plea agreement in this. I think you should have a copy in the file there.
Yep, I've got it. Hello, Mr. Hammer.
How you doing?
I'm doing all right, sir. You ready to go?
Yes, sir.
Okay. Will you raise your right hand for me? Do you swear to tell me the truth, so help you God?
Yes, sir.
Okay. My first question, Mr. Hammer, concerns this motion to enter a guilty plea. Does this look familiar to you?
Yes, sir.
All right. It appears to be to contain your signature. Is that your signature?
Yes, sir.
Okay. My next line of questioning goes along with this offer from the Commonwealth. Does this look familiar?
Yes, sir.
All right, sir. It also appears to contain your signature. Is that right?
Yes, sir.
Did you read over both of these documents
Yes, sir.
before you signed them?
Yes, sir.
Are you comfortable that you understand both documents?
I have one thing. I said it was $1,000 fine, but he said it's supposed to be probated.
Yeah. Yeah.
Okay.
We'll talk about that when we get there.
Okay, yeah, that's
Yeah,
the only question I have.
Okay. All right. Fair enough. So, do you feel like you're under the influence of anything right now?
No, sir.
Do you feel like your judgment is impaired for any reason right now?
No, sir.
All right. Has anybody made any threats towards you to try to get you to plead guilty?
No, sir.
Have you discussed with your attorney the Commonwealth's offer and the proof in the case and what your options are?
Yes, sir.
Okay. Mr. Hammer, do you understand that you have the right to remain silent? You have the right to a trial by jury where the burden is on the Commonwealth to prove guilt beyond a reasonable doubt. You have the right to confront and cross-examine witnesses and the right to put evidence on in your own defense. Finally, you have the right to appeal the outcome of your case to a higher court.
Yes, sir.
You understand those rights?
Yes, sir.
Do you understand that you are waiving those rights if you plead guilty?
Yes, sir.
All right. Mr. Hammer, the Commonwealth has agreed to the following recommendations, it looks like. Count 1 is assault, 4th degree domestic, third or subsequent offense within 5 years. That's a Class D felony. The Commonwealth agrees to recommend a sentence of 5 years plus a possible fine and court costs. Count 2 is public intoxication. The Commonwealth agrees to recommend a sentence of 90 days. The Commonwealth would agree, well, those sentences would run concurrently for a total of 5 years. The Commonwealth would agree to supervise probation after service of an alternative sentence of 120 days, which would include credit for time that you have spent in this case. I don't know if you spent the full 120, but they're not opposed to giving you credit for the time that you have been in custody. Your probation is would be supervised and would be conditioned on you getting an assessment and complying with any sort of recommendations that might come from that assessment. It would also be conditioned on you not having any direct or indirect contact with the victim in the case. Do you understand all of those things?
Yes, sir.
Do you believe that I have accurately stated what the agreement is?
Yes, sir.
Okay. Mr. Hammer, other than what you and I have just talked about, has anybody promised you anything to try to get you to plead guilty?
No, sir.
All right. Let me see. Are you pleading guilty voluntarily?
Yes, sir.
You acknowledged to me here today that on September 17th, 2020 in Barron County, Kentucky, you intentionally or wantonly caused physical injury to another person, having been convicted at least 2 prior times of assault in the 4th degree domestic violence within the last 5 years. And the victim in this case was a person who met the category of domestic violence, which would mean that they were related to, she was related to you within the 2nd degree. You were married, you were currently or formerly living together, or you had a child in common.
Is my lawyer on there?
Yes.
I asked him if I could plea an alpha plea. So, I mean, can I put?
Judge, me and Mr. Berry talked about that, and I said I wanted him to accept responsibility. If he doesn't do that, there's no deal.
Yeah, I mean, this is not an Alfred plea because that wasn't the Commonwealth's offer.
He had asked me Friday if I would ask about that, and he said he still wanted to do it if they wouldn't go along with it. So I did ask, and they didn't want to do that. So.
All right, then I'll plead guilty.
Okay. Are you acknowledging those facts that I just laid out to you?
Yes, sir.
All right. Are you also acknowledging that you committed at the same time the offense of public intoxication when you appeared in a public place manifestly under the influence of a controlled substance to the extent rather that you endangered yourself or other people or unreasonably annoyed people in your vicinity?
I was at home, but I plead guilty.
All right. Mr. Hammer, do you believe that you did your 120 days already?
Yes, sir.
Judge, he did. I calculated 138. He's been in since September 17th. So
okay, I just wanted to be sure because if there was a question about it, I was going to put somebody on that real quick so that we could let him know today. But if everybody agrees to that, then we'll. What that will mean, Mr. Hammer, is that I'm going to accept your guilty plea, and so you're going to need to be making your plans for what happens when you get out of custody because you're going to get out. One of the plans is you're going to have to report to probation and parole. I got somebody on here, I do believe. Officer Bray.
I am on here, Judge.
Yeah. He's going to be getting out. So, and he's going to be getting out on supervised probation, Officer Bray. So give him his marching orders, will you?
Yes. Mr. Hammer, I want you to report to probation parole office at 8:30 in the morning, okay?
And where's that at?
That's 100B Reynolds Road. You know where on Happy Valley, like you're going toward Walmart in Glasgow.
Yeah.
You know where that new car dealership is, the Franklin, Don Franklin,
Yeah, okay, I know where you're at.
right across the road.
Okay.
All right, Reynolds Road.
Mr. Hammer, are you planning on living, will you be living permanently in Barron County, or are you gonna move?
No, I'm moving back to Monroe County.
Okay, well, I know you've kind of lived in different places, so, in either, Barron or Metcalf or Monroe. So what you need to do is report to this office here and then discuss with them what has to happen to get that supervision, okay?
Okay.
You want me to send it to you today?
Yes, sir.
All right. All right, Mr. Hammer, so I'm accepting your guilty plea. We'll go ahead and impose your sentence. That's 5 years and 90 days concurrently for a total of 5 years. Credit for, it'll be a little bit more than 120 days, but the alternative sentence was 120 days, so you get credit for time served, balance suspended for a period of 3 years on condition that you comply with probation and parole, specifically those conditions that we have just recently discussed in your motion, or I'm sorry, in the Commonwealth's offer. And also, you need to be sure you report as Officer Bray directed you tomorrow by 8:30 a.m., okay?
Yes, sir.
All right, your fines and your court costs, I am going to consider that your, that your court cost is served out by that alternative sentence, all right? I'm gonna probate your fine, so as long as you stay out of trouble and don't get your probation revoked, you're not gonna have to pay your fine, okay?
Yes, sir.
You have any questions?
No, sir.
All right, thank you.
Uh-huh.
Bobby Johnson?
This is my case, Mr. Berry's, and we're kind of at a standstill right now. I've made an offer before, and Mr. Berry and I had talked last week, and I inquired about whether or not he would consider my offer and give me a counter, and basically was told that he wants to ask for a release on bond and didn't even give me a counter. So we're kind of at a standstill right now.
Okay.
Judge, he had a sanction he was doing on a probation revocation motion, and he has served that out. But I believe his bond was revoked. Well, I don't see the date on it, but I believe in January, sometime December or January.
December.
Okay.
I told Barry that I'd be willing to, we'd be willing to come to an agreement, but I was wanting to be able to go to the doctor. I hadn't, I missed my, lung specialist the 18th of this month. If I could get out and get that in order and maybe save up a little bit of money before I have to come back and do this time. I know I've got to come back and do some time. That's all I was asking. I mean, well, I feel that we're going to be able to come to some kind of agreement here in the next month or so. I still have my job. I'm still on probation, so I'm still going to be supervised.
Okay. So what you're asking me right now is to reinstate your bond. Is that what you're asking?
If you could, sir, please. I'll make sure that I'll let Barry know everything about my doctor's appointment, or where he can send it in to y'all or whatever.
Here's what the problem has been, is that you've had to stand out on bond when I let you out.
I understand, and I did, Judge. I just was back in jail before my appointment. But I mean, I got in trouble for something that it wasn't me. I got in trouble for just riding with somebody.
Judge,
I won't do that again.
Mr. Richardson may know this better than I'm remembering. I think, is there another possession case coming up?
I mean, he's got a, pending possession case. And when we had talked, I said I was willing to work with y'all on that, but I'm really not budging on the jail time for he's got 2 different fleeing and evading cases.
And I understand that. I see that, but what I'm saying is I'd like to, I had no money up here. Nobody sends me nothing or nothing. So if I can get out and get repaired to come back, I mean, I'm willing to do the offer or whatever.
Judge, I mean, my thing is I'm not going to agree to any type of release, or I would oppose it. He's got 2 different fleeing and evading cases. Now this new, pending felony charge. I mean, I wouldn't feel comfortable with it. It's my opinion.
I mean, I see your point. You're gonna have 3 felony cases plus however many y'all on probation for. How many is that? 1 or 2?
1.
Mr. Berry? This is going to be an awful lot like a case that we had last week, although I don't think it was your case, so you might not remember the conversation that I had because you wouldn't have been necessarily paying attention. But, him telling me that he's going to work out an agreement, if I just let him out, is pretty ephemeral in the sense that you can't sink no hooks into that. On the other hand, if you all worked out an agreement and then he asked me to, and he entered a plea, and then he asked me to give him some time pending a sentencing to take care of some matters or whatever, there would at least be some leverage there that I know he would not be lying to me. I don't think he's lying to me now, but I think that he has less incentive to mind his manners this way. I mean, if Mr. Johnson is serious about trying to work out all 3 of these felonies, and you all can come up with an agreement, then I'd feel a lot better about. I mean, my position right now is a whole lot like Mr. Richardson's position, which is that he keeps getting out and then he picks up another felony and has to go back to jail, and now he's worked up 3. And I mean, I feel like I almost feel like I'd be partially responsible if I let him out and he got another one. Because every time I let him out, he picks up a new case. I know he doesn't mean to, but I mean, I know you're not getting out with the plan to pick one up, but I mean, it just seems like it finds you.
Understand.
Understand what I'm saying? And I know you've got some medical things that you want to go see a doctor about. And I feel like that also helps you, gives you some incentive. But I mean, I'm a little, I just here lately, your track record has not been real good, Bobby, when I let you out.
I understand.
And especially with your health issues, you ought to be kind of taking it easier, and trying to preserve your lung capacity rather than running around out here getting new charges and catching new felonies. Okay.
Yeah.
This is my plan. And I know, I mean, I'm going to, it'll be, yeah. I'm gonna put him on, Mr. Berry, for the 22nd. The reason I'm gonna put him on for the 22nd is because the grand jury will meet again between now and the 22nd. And if he gets indicted on this possession charge, or in the alternative, if you guys talk about it and maybe there's a workout or something, either way, we'll come back on the 22nd. I can arraign him. If y'all have an agreement, fine. If you don't, at least he's got all of his cases up here. I know where we are. We'll talk about your bond, Bobby, at that point. Whether you enter a plea or not, we'll talk about, your bond and, but I'd like to get everything all consolidated in together and let the Commonwealth, Mr. Richardson's promising you that he's going to try to, work with you on it. So I'll let him get the chance to make an offer to you. And if you take it, you take it. If you don't, you don't.
All right.
Okay?
All right. I missed. But I don't know. I don't know. I didn't hear him.
All right, Colton Keller. Mr. Keller, first
Judge.
got is arraignment. You got indicted in earlier this month, in January, I'm sorry, with possession, controlled substance, first degree, first offense, driving on a DUI, suspended license, aggravated drug paraphernalia, and DUI. Do you need me to explain your rights to you?
No, Judge.
Do you need me to explain more details about your charges or your indictment to you?
No, Judge.
All right. Mr. Keller, do I need to appoint a lawyer for you?
Yes, please.
All right. I'm going to appoint the public defender's office to represent you. Enter
Judge,
to plea on your behalf.
Judge, I can't talk today. This will be my case. I have his original case. I've had some preliminary discussions with Ms. Gardner on this, so we're going to try to work them both out together, hopefully.
All right.
Yeah, Judge, just so the court's aware.
Sorry, go ahead.
Just so the court's aware, I think I indicated that coming out of the grand jury that I'll be handling this case, but Risa is going to be the one. She has the other pending case that he has now, so she's going to handle this case as well.
All right. All right, when would you like me to set it over to Mr. Spears?
If we can put it on the 22nd, that would probably be good. That'd give me hopefully the Commonwealth enough time to get me to discovery. And then I can talk to Colton. Hopefully maybe we can get some kind of universal resolution, or at least know where we're going by that point.
All right. 2/22 at 1 o'clock. Jonathan Kirk.
Judge, Mr. Kirk, Josh and I talked last week. There was some additional discovery I received in the form of surveillance video. I provided to Greg because Mr. Kirk's co-defendant, Cody Neal, as part of his file, I sent that over to Greg. I think Josh may have a copy at this point.
Well, I haven't seen the copy yet, but I think it's in the office somewhere. I just get a chance to review it. I was going to ask to push it off a week.
Okay.
All right, I can do that. 1 week?
1 week, and I'll be up to see Jonathan as soon as I review it.
It's 2/8. All right, thank you. Stanley Merrill.
Judge, this is my case. I've talked to Mr. Merrill. We have an offer in this case. He's not willing to accept it right now. There's some outstanding, I don't know, it may have already been sent to our office and it's not processed yet, but there's some body cam footage I would like to review. So if we could put this off for the 22nd to give me enough time to review that body cam footage, we should be close to a resolution by then.
Okay.
And one other thing Mr. Merrill wanted to bring to the court's attention. Granted, this may be this may be out of your jurisdiction or ability to be able to do anything about it due to the fact he's a state inmate. But Mr. Merrill is asking for some kind of setup to where he could go to an outside doctor to get like a physical checkup. I mean, the court is well aware of Mr. Merrill's medical condition. And he has told me that they're getting worse, and he feels like out of the realm of the medical care that can be provided by the jail. So he was asking for some kind of like a furlough, or even like a potential like a supervised visit to either the hospital or his doctor or some primary care physician to get all this stuff checked out.
Yeah, well, because he's a ward of the state at this point, and it's up to the Department of Corrections whether he gets a furlough or whether he goes to a doctor, or if they send him somewhere else or come get him and take him to another facility or whatever the case may be. I understand the point, and I certainly, understand his health issues because we talked about that the last time, but I don't have the authority to release him from custody even temporarily.
Okay. Well, I'll look into the DOC route then.
Okay, fair enough. We'll put it on for 2/22. Is that what you said?
Yeah, 2/22.
Yeah, 2/22. All right, thank you. Honey, I will let you excuse yourself out of the meeting so you can get back in, okay?
Okay, Judge.
The judge, when the new group comes in, Mr. Basil was waiting for Jody Tucker. Needs to do a reschedule a pretrial.
Okay. Let me, I know we've got some other folks here we can take care of, and I'll get right back and we'll do those, but I need to take a real quick break and take care of something. All right. All right.
What's going on now? What Heather say when she called back?
Hey, Wes, you're not on mute.
I just told her, I said, yeah, Wes, make sure.
Thank you.
Hello. Mm, mm. Oh, damn. Mm. Mm. Fuck. Mm, 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 mm. We're done. Mm.
All right, y'all. See what all,
Judge, can we get Michael Perkins?
yeah,
He's a rocket docket. He's been hanging around for a while.
all right. All right, Mr. Perkins, can you hear me?
Yes, sir.
Mr. Perkins, will you raise your right hand? You swear to tell me the truth, so help you God.
Yes, sir.
All right. Mr. Perkins, I've got several documents I need to go over with you, okay?
Okay.
Start by asking you, can you tell me your address?
3745 Homer Bartley Road, Somerset, Kentucky, 42166.
I got you. So that's a Somerset address and not a Tompkins. It's, they had you on
Yeah.
Tompkinsville, and something didn't seem right. That's it.
Yeah, I live about a mile and a half past the Monroe County line.
I went by the citation. Sorry.
Oh, yeah. No, sure. Yeah, I mean, it's only as good as the information you get, but I was thinking that was not Tompkinsville, and that's why I wanted to ask you. All right. So, Mr. Perkins, in this case, the Commonwealth has indicated to me that you have agreed to enter a guilty plea based upon an agreement that they have reached with you, the details of which we'll need to go through in just a minute. But the first thing I need to ask you is it your desire to enter a guilty plea today?
Yes, sir.
Are you doing that voluntarily?
Yes, sir.
In other words, do you feel like I'm trying to make you do it or anybody else is forcing you to do it?
No.
All right. The Commonwealth has prepared various documents, and I'm going to ask you if you understand or have seen those documents. First off, this one is called a waiver of rights. I'm going to kind of scroll up like that, and then I'm going to move over to the last page. And the reason that I'm doing that is because it has kind of not an actual signature, like an electronic signature, I guess is the way to put it. But have you seen that document?
Yes, sir.
All right. Did you have all the time you needed to go over that, look at that, ask questions about it, etc.?
Yes, sir.
Did you authorize, looks like maybe it was Miss Hill. Did you authorize Miss Hill to sign your name to it?
Yes, sir.
Okay. The next document is this motion to enter a guilty plea. Again, I'm going to kind of scroll up so you can see the whole thing, right?
Yes.
The same deal on the back page of that. It's got signed by you, but that's not technically your signature.
Yeah.
Have you seen this document also?
Yes, sir.
Have you reviewed it and discussed it with your attorney?
Yes, sir.
All right. Did you authorize her to put a facsimile of your signature on there?
Yes, sir.
All right. This is the Commonwealth's written offer on a plea of guilty. I'm scrolling up there, and the back page of it has the same kind of deal, kind of a virtual signature on there. Okay?
Yes.
It shows what you're charged with and what the Commonwealth would agree to recommend if you plead guilty. Do you remember looking at that document?
Yes, sir.
And did you authorize your signature to be placed on that document?
Yes, sir.
Or your a representation of your signature? Okay. So, Mr. Perkins, do you understand that you have a right to remain silent and that is waived if you plead guilty?
Yes, sir.
Do you understand that you have the right to a jury trial where the Commonwealth has to prove guilt beyond a reasonable doubt? You could confront and cross-examine witnesses, and you could put evidence on in your own defense. You could also appeal the outcome of those proceedings, but those rights are all waived if you plead guilty.
Yes, sir.
Okay. Now, as we sit here today, do you feel like you're under the influence of anything?
No, sir.
Do you feel like your judgment is impaired for any reason today?
No, sir.
Do you feel like you are being forced into an agreement that you don't want to enter or you don't understand?
No, sir.
All right. Mr. Perkins, we'll cut right to the offer. You have a single charge, possession of a controlled substance, first degree, first offense. That is a Class D felony. The Commonwealth agrees, if you plead guilty to that charge, to recommend a 1-year sentence. That 1-year sentence, however, you would not be sentenced on, but you would be subject to pretrial diversion on the condition that you enter and complete drug court. Your pretrial diversion would last as long as it takes you to complete drug court, which I'm sure that you've been, I know you've been assessed because Candy sent me all of that, but I'm sure that they talk a little bit to you about that. And it's, generally, if you do everything you're supposed to do, you can get it accomplished within a 2-year period of time. Okay?
Yes, sir.
All right. The Commonwealth agrees to dismiss your charge. Originally was enhanced by possession of a weapon, which the Commonwealth agrees to dismiss as part of your plea. Therefore, your total recommended sentence would be 1 year, but with pretrial diversion. If you successfully complete drug court and thereby also complete your pretrial diversion, then the charge will actually be dismissed, at which point you can wait a very short period of time and get it expunged, and it won't show up on your record for any reason, background checks or anything else. Okay?
Okay.
All right. So you really have an awful lot of incentive, because not only do you just get a felony charge dismissed, but you can also get it completely removed where nobody would ever be able to see that you had it. And, that's a pretty good deal. Okay?
Okay.
All right. Do you want to ask me any questions about that?
No, sir.
All right. Again, are you entering this agreement voluntarily?
Yes, sir.
Are you acknowledging to me that on the 23rd day of December, 2020 in Barron County, Kentucky, you knowingly and unlawfully possessed methamphetamine?
Yes, sir.
All right, Mr. Perkins, I'm going to accept in your guilty plea here today. I believe that we can also move forward with your pretrial diversion agreement, because it is, a standard deal that we do. Did Candy tell you, or any of the folks at drug court tell you when you needed to get in touch with them?
I've already contacted court. Oh, go ahead.
I just texted Candy. He's already reporting and participating. So he just needs to continue doing what he's doing.
Super. Is Corey your case?
Yes, sir.
All right, very good. So you keep on doing what you're doing. We'll get all the paperwork done on this end. At some point, next time we have a drug court meeting, I'll see you there. But we don't have them quite as regularly as we used to, since everybody can't be in the same place, but we still, try to get together once a month or so. Okay?
Okay.
Do you have any questions, sir?
I don't have to appear in court the 4th in front of Pendleton now, right?
That's correct.
Okay.
The only thing besides just regular old going to drug court that I'm going to be asking you to do is, you're not going to get a fine, but you do have court costs, which is, what is it, $165? I don't know. Crystal will have to tell us. Which I'm going to, you just have to pay that court costs as part of your drug court. So really you get, you have $190 in court costs. So, just remember to pay that. You can pay it a little bit at a time. You can't get out of drug court until it's paid, but I'm not going to talk you over. You're going to be, if we get to that point, you're going to want to pay it to get out of there. So you can pay a little bit at a time or whatever you want to do. Okay.
Okay. I'll pay it as soon as possible.
All right. Good deal.
Thank you, sir.
All right. Any questions?
No, sir.
All right. You're free to go. Thank you.
Thank you.
Yeah. As a condition of completion. All right.
Judge, could we?
Benigni.
Yeah, okay. I was going to ask if we could do Brittany. She's been on here since, I believe, the start of it.
Yep. What are you all having in mind here with Miss Brittany?
Well, we don't have a result. have it resolved, Judge. I do think there's a good possibility we can get this resolved, though. From talking with Brittany in the past, I believe we can. But if we could just put it off, again, I'm saying I don't think we have a trial date set. Last time I said that we did in fact have one, but I don't think we have one on Brittany's case. If
Judge.
Yeah.
I'm sorry. I'm just standing in for, John just asked for a new pretrial, Greg. He hadn't had an opportunity to discuss the counter offer with the cabinet, so.
Oh, okay.
I don't think there's a trial date.
Well, that's with 4 weeks.
Yeah, I was gonna say March 1st or 8th.
Okay. March 8th.
Either's fine.
Okay.
Is that all right with you, Brittany?
Yeah, 3/8.
I don't want to go to trial.
Okay. Okay, well, let's not talk about that right now. Just, is March 8th okay? And we're not talking about a trial date. We're talking about another pretrial conference.
Okay. Am I going to be able to talk to you soon about the deal that you had said something to Commonwealth about?
Yeah, I'm kind of waiting to hear back whether they are interested at all.
Okay.
Okay.
All right, Brittany, so we'll have you getting back on here on March the 8th. That's 5 weeks from now, okay?
At what time?
Same time.
Okay. All right. Thank you.
All righty, take care of yourself.
You too.
All right, let's see. Looks like we got Charles Busey. He's trying to fool me into thinking he's Mike Herzog, but I know better.
Your Honor, John and I each have a case on Mr. Busey.
Okay.
Judge, I have.
And
Go ahead, Risa. Sorry.
No, you go ahead.
I was going to say was, I'm waiting for Mr. Busey to get back in contact with me. Since he's been released, he wanted me to speak to a witness, but he was waiting to get released on parole so he could get the contact information to me. He hasn't yet. So if we could push this off to March 1st, hopefully I can get all that taken care of and we can move forward on this case. These cases.
Can you get in touch with Mr. Spears in the next week or so?
I've been trying to. I got the number. I called up her. I went to the jailhouse, got his number. I've been trying to call it and nobody answered. So I don't know. I went to the office 3 times already.
Well, we're going to give you, can you write on something? We'll give you another number.
Yeah. Let me find a pen. Oh.
Charles Busey.
Okay.
You got a pen?
Yes.
All right. Try this number, 833.
833?
Yeah. 385. 6055.
6055.
Yeah.
385.
Yeah. Okay. 833-385-6055. Yeah, that.
833-635-6055. Okay.
Yeah, just call that between 8 and 4:30. Somebody will answer. Somebody should
All right,
answer.
I will.
All right.
I'll call you tomorrow if you get in contact me.
That'll be good.
All right.
All right. So what day did you say you wanted that on, Mr. Spears? I can't remember.
March 1st. Let's move it a month. We're not stacking stuff on the 15th and 22nd so bad.
All right. See you then, Mr. Busey. Don't forget to call. All right.
All right. Thank you.
All right. Boom. All right. So we have the jail back on here.
Judge, can we call up Jody Tucker first?
Did you say Mr. Tucker? Is that what you said?
Yes, sir.
Okay.
Judge, I talked to Mr. Basil earlier, and if we could put this on for March the 1st, he has another felony case in Butler County coming up shortly after that. And I need to talk to the victim again in this case, to see if we can resolve this here in his Metcalf case.
Do we have his Metcalf file over here, do you think? We don't, do we? Okay. You want to put both the Barron and the Metcalf on?
May as well, yes, sir.
All right. I can't remember, Scott, if you're handling the Metcalf or not. Are you?
I am, Your Honor.
All right.
This would take that off the calendar for tomorrow.
Oh, is it on tomorrow?
Well, I guess
Probably
it's
next-
not. I thought it was.
Yeah, it might be next Tuesday, because we don't have court tomorrow over there.
No, it's not on then either. I was mistaken.
Eh.
Who'd have thought?
It's got to happen every now and then. All right, so we'll see you on March 1.
Thank you, Your Honor.
All right, thank you. Let me do an OTA on that, yeah. It's a really neat painting. It's pretty nice. All right, all right, all right. Scott Basil. All right.
Judge, I have somebody waiting to enter a plea if the jail's not back yet.
Yeah, the jail is back, but we can do that plea if you want to.
Okay, it's Catherine Altitas. I'm not sure.
Okay, yeah.
Okay. She's on here somewhere.
His situation is he's got a bond.
Here.
Okay.
All right, so let us see.
She's under Wolf.
Yeah, I see her.
Okay.
Is it what's moving around a lot? All right. Ma'am, are you ready to go?
Yep.
All right. Is it Iatitas?
Iotitis, yeah.
Iatitas, okay. Very good. Will you raise your right hand for me? Do you swear or affirm that you'll tell me the truth, so help you God?
Yes, sir.
Okay. Thank you. Ma'am, I'm going to ask you to take a look at screen. I'm going to show you, let me find, there I am. All right, to make sure that you all this. This is a document that's called Motion to Enter a Guilty Plea. On the back page, it appears to have been signed by you. Is that your signature?
Yes, sir.
All right. This is a document that's called the Commonwealth's Offer on a Plea of Guilty. Again, on the second page or back page, it appears to have been signed by you. Is that your signature?
Yes, sir.
All right. Did you read over both of those documents before you signed them?
Yes, sir.
Do you have any questions that you did not get the chance to discuss with your attorney?
No.
All right. Did you understand what you signed?
Yes.
All right. Do you understand that you have the right to remain silent, and if you plead guilty, you waive that right?
Yes, sir.
You have the right to a trial by jury where the Commonwealth has to prove guilt beyond a reasonable doubt. You can confront and cross-examine witnesses. You can put evidence on in your defense, and you can file an appeal. If you plead guilty, you waive those rights. Do you understand?
Yes, sir.
All right. Do you feel like you are under the influence of anything today?
No, sir.
All right. All right, Ms. Iatitas, I'm going to look at the offer that you have signed. The Commonwealth has made the following, or has offered to make the following recommendations on a plea of guilty. Count one, possession of a controlled substance, first degree, first offense. The Commonwealth agrees to a 2-year sentence. Drug paraphernalia, Commonwealth agrees to a 12-month sentence. Driving under the influence, Commonwealth agrees to a sentence of 30 days plus a possible fine, a DUI service fee, DUI counseling and license suspension. Count four, no operator's license. The Commonwealth agrees to a 90-day sentence. Counts 5 and 6 are registration-related charges. The Commonwealth agrees to dismiss those. The total recommended sentence by the Commonwealth would be a 2-year sentence, plus those DUI sanctions of service fee, counseling, and suspension. The Commonwealth agrees to probate that sentence for a period of 3 years on the condition that you're supervised by probation and parole, that you comply with the terms of probation and parole, and that you get a substance abuse assessment through your probation officer if anything is recommended as a result of that assessment. You would need to follow that. Do you understand those recommendations?
Yes, sir.
All right.
Yes, sir.
Other than what you and I have just talked about, has there been any promise made to you to try to get you to plead guilty?
No, sir.
All right. Are you pleading guilty voluntarily today?
Yes, sir.
All right. Are you acknowledging to me that on September 5th, 2019, in Barron County, you knowingly and unlawfully possessed methamphetamine and drug paraphernalia?
Yes, sir.
All right. Are you also acknowledging to me that at that same time and place, you operated a motor vehicle while under the influence of a substance or combination thereof that impairs your ability to drive?
Yes, sir.
Are you also acknowledging that you were driving without a license or knowing that your license had been suspended or revoked?
Yes, sir.
All right. Then I am going to accept a guilty plea here today. And let's see. And we're going to move on to, can you tell me real quick where you are right now? Just, I mean, in general terms, what county are you in?
Like living in? I live in
No,
Hart
just
County,
like,
in
just like
Mumfordville.
right now, where are you?
Oh, right now I'm in Elizabethtown in Hardy
All right.
County.
All right. And where are
But
you? What's your residence of county of residence?
Hart County.
Hart County. All right. Are you in any sort of treatment facility, or are you just in Elizabethtown? I mean, you don't have to. I'm not trying to be nosy. I'm trying to figure out how you're going to go meet your probation officer.
Well, I mean, I'll have to drive there.
Yeah. I mean,
I get a ride there.
right now, you're free to travel right to your probation officer.
Okay. If I can, I might have to go to probation.
You're not in a situation where you're in like a treatment facility and you can't travel around, is what I'm trying to ask.
No, I can get rides.
All right. I've got Officer Bray on here. Here's the way this generally works. You have to report to the probation initially to the probation office where, your offense occurred. And then they will go over with you what needs to happen to get your probation transferred to whatever county you're going to be living in. So your first report to the office here in Barron County. And then after that, there'll be some paperwork to get done or whatever, and then you'll be able to start reporting wherever it is that you're going to be. Okay?
Okay.
All right. Officer Bray, you want to jump on tell her what she needs to know?
Yes. Ma'am, you can report to the Glasgow office tomorrow at 9 o'clock, okay? Do you know where the address is?
Okay. No, I don't have
You know
that
where
address.
Okay, it's 100B Reynolds Road, REYNOLDS, Reynolds Road, Glasgow, Kentucky. Do you have a GPS system?
Reynolds. Yeah.
Okay, you can GPS it then.
Okay, at 9 o'clock?
9 o'clock, 9 a.m.
Okay,
Yeah, and that'll be, that'll be this local time. You're on the, if you're in Hardin County, you're on the fast time. This will be the central.
right,
Okay?
okay.
So ma'am, I'm going to accept your plea of guilty today. I will go ahead and, unless you ask me different, I'll go ahead and sentence you today as pursuant to this offer, which you have accepted to 2 years. You'll have the DUI. I'm going to waive your fines. I'll go ahead and waive your court costs. You have a $425 DUI service fee that cannot be waived, which I'm going to give you 6 months to pay. You've got the DUI counseling and license suspension, which I cannot waive, of course. So those will apply.
Okay,
And you'll report to probation and parole as indicated. Just do what they tell you once they talk with you, and things ought to work. Okay?
okay. I do have a question. The 30 days, I talked to my attorney. Would that go with the probation? Like, okay,
Yes. You're not getting 30 jail days on that. You're just getting probation.
okay.
What address will you be, if you know your address, can you tell me? Because we obviously don't have a Hart County address for you.
Yeah, 175 Woods Road,
Okay.
and that's apartment 75. And that's Mumfortville.
You said 75?
Yes.
Okay, thank you. All right, ma'am, got you covered, okay?
Okay, thank you.
Have any questions here?
No.
All right.
That was it.
All right, thank you for your patience.
All right, thank you.
Mr. Perry, did you tell me you have one more?
Got one, he's in jail, Charles Young.
Oh, okay.
I didn't know if you wanted to take some of the others before him or not, but
It's up to you. I thought you had said, I've got one I can do while we're waiting, but it was her, wasn't it?
you're right, right.
Yeah. All right.
I filed Mr. Young's paperwork also.
Gotcha. It's right here in front of me. Good deal. I've lost the jail. All right, there he is. Hello, Mr. Young.
How you doing, sir?
I'm doing all right. Can you raise your right hand for me? Do you swear to tell me the truth, so help you God?
Yes, sir.
All right, thanks. Mr. Young, got some things here. This is a motion to enter a guilty plea. You've probably seen one of those before, but I want you to see what I'm looking at.
Yes.
It appears to have your signature on it, which is on this second page right here. Is that in fact your signature?
Yes, sir.
All right. Commonwealth has also made an offer. It's right here. Does that look familiar to you?
Yes, sir. Yes, sir.
And then here's the second page. Is that your signature?
Yes, sir.
All right. Mr. Young, did you go over both of these documents before you signed them?
Kind of, yeah.
Well, kind of.
Yeah. Hey,
Well-
they was in a rush to get me to sign them.
All right. Do you need more time?
Now, go ahead. Go ahead.
No, if
Did you
want to
have?
take time, Charles, that's all right.
Yeah, I'm not trying to, nobody's trying to force you into anything. So if you don't think, well, I'll tell you what, let's go over it and we'll discuss what it says. And if you have questions or you don't feel like it's something that you actually did agree to or whatever, then we'll stop. Okay.
Okay.
All right. First off, let's talk about pleading guilty. Do you understand that nobody can force you to plead guilty? If you do plead guilty, you're waiving your right to remain silent. You understand that?
Right.
You have a right to a trial by jury where the Commonwealth has to prove guilt beyond a reasonable doubt. you can confront and cross-examine the witnesses that testify against you and put evidence on in your defense. You would be waiving those rights by pleading guilty. Do you understand?
Yes.
You have the right to appeal, and you waive that if you plead guilty. Do you understand?
Yes.
All right. Mr. Young, are you under the influence of anything right now?
No, sir.
Judgment impaired right now for any reason?
No, sir.
All right. So let's move on then to talk about this offer. The Commonwealth's offer is as follows. You have a single count in your indictment of failure to comply with the sex offender registration law, second or subsequent offense. That's a Class C felony. The Commonwealth, on a plea of guilty, would agree to recommend a 5-year sentence plus a possible fine and court costs, and would oppose probation. Do you understand all that?
Yes.
All right. What it says on here is that this sentence would run concurrently with 19 CR 411 and 19 CR 382, but would run consecutive with any other sentence that you might have. Is that what you understand?
Yes.
All right. I don't, that information, just Mr. Young and Mr. Richardson, just by virtue of, since I'm holding this up, that's the information that's written on this, you know, like where all that's typed and then that information is written. All right. So, Mr. Young, that is what appears to be the recommendation of the Commonwealth, and you signed off on it. But from what you said, I want to make sure that that's what you have agreed to. Is that what you agreed to?
Yes. Yes.
All right.
Yeah.
All right. So do you feel comfortable going ahead with this, or do you feel like you need to stop and talk to your attorney more?
Now, does that run concurrently with the 3 years? To be a total of 5?
Mr. Berry, here's where I'm at a little bit of a loss, is because I don't remember what those other cases, you've referenced those specifically, but I don't remember what his sentences were on those.
Judge, two of the, let me interrupt. I already looked at it. It's 3 years in 2 different cases, I think. And the whole point was to run it all concurrent. That was their request as part of the counter offer. So that's what he's talking about. Those cases have the 3 years in it.
Yeah. So if his sentences in 19 CR 411 and 382 are 3 years, and then this is a 5-year concurrent with those sentences, then the total is 5 years.
Right. That's what our understanding is, Judge. And that's what I told Charles.
Which I believe is responsive to your question, Mr. Young. This sentence is concurrent with those 2 cases. That is what I assume you're in there for.
Okay.
Yeah. All right. Mr. Young, other than what we have just been discussing, did you think you'd agreed to anything else?
No, just in 30 days have shock probation.
You do have you do have the right to ask for shock probation. The Commonwealth has made it's probably not a condition, but has indicated clearly on its offer that it doesn't agree to probation. And if you ask, they're probably going to oppose it. Do you understand that?
Yes.
Nobody has promised you shock probation. Am I right?
No.
All right. You can always ask, which I assume is what maybe you and your attorney have discussed.
Yes.
All right. Mr. Young, do you feel like I'm making you enter this agreement?
No, sir.
Okay. This allegation is that from June 1, 2020 to August 29, 2020 in Barron County, you committed the failure to comply offense when having previously been convicted of 3 counts of sexual abuse first degree and subject to registration under KRS 17.510 or prior law. You failed to register a new address with the local probation and parole office within 5 days of moving from a previous address, and you have been convicted at least one time previously for the same failure to comply offense. Are you admitting that today?
Yes.
All right. Mr. Young, I am going to accept your plea of guilty, and then Mr. Barry, if you and Mr. Young are okay with it, I'll go ahead and sentence him today. Is that fine?
That's fine, Judge. You want to go ahead and be sentenced now, don't you, Charles, instead of waiting?
Yes.
Okay.
All right. Mr. Young, that's what we'll do then. I've accepted your plea. I'll go ahead and sentence you. And that gets any time frames running if you're planning on filing something, okay?
All right.
All right, sir.
All right. Thank you.
Okay, thank you.
Judge, could we call Jason Smith? He is a co-defendant of Tanisha Shirley.
Okay.
This is one we had set for a pretrial today, and we did not get the discovery out until last week because Darlene was out with the COVID situation. So we just need to set another pretrial so Josh can go over the discovery.
Yeah,
And Greg.
I have it now. I have it for Mr. Smith. So if we wanted to put this on next week or the week after, that's fine. I can get up to the jail and see him and get the discovery to him.
Either's fine with me.
All right, why don't we do, we can do the 15th.
Okay.
All right. See you then.
Your Honor.
Yes.
Could I'm here on 5 years for Marshall County. I ain't going nowhere. Is there any way I can get my bond lowered, where I can get my classification lowered, where I can go to work?
I
mean, I'm doing 5 years for Marshall County.
Yeah, I mean, I don't theoretically have an issue with that. Amy, are you on here? Can you, I guess he's a state inmate. Is that confirmable?
Yes, Your Honor. I don't have a note on it in his holders, but let me double check on that. I'm just showing this one, but let me confirm his holder information.
And Your Honor, as far as the Commonwealth goes, I don't necessarily have an objection if he's wanting to work while in custody, but I can't say that I don't want him to have the impression that we're going to resolve this and he's going to be out like for probation, but
yeah.
As far as,
I don't think you're committing to anything. Yeah.
yeah, but if he wants to work, I don't have a problem with that.
Yeah. Mr. Smith, if I'm gonna move on, but if Amy checks on that and she can tell me that, confirm for me that you're serving that state time, then I'll go ahead and do that so that you can get some other things accomplished while you're in there. Okay?
All right. Thank you, sir.
All right. Thanks.
Jason, I'll be up there.
All right.
Hey, I'll be up there as soon as I can with your discovery.
All right. Thank you.
So that's for both Shirley and Smith.
Yeah, well, I need to get Miss Shirley up here. I think she's
Okay.
an attorney that's waiting. Hello, Miss Shirley.
Hey.
Miss Gardner, I think this just got filed today, so I guess you haven't seen it, but this is Mr. Price, who is from Elizabethtown, and he has entered an appearance for Miss Shirley today. So I don't know that he's gotten any discovery. He might be interested in seeing some of that.
And Your Honor, I got that from the DPA office. Miss Shirley, I'm going to get that over to you. I'm going to put that in the mail this week. I just received that today. You'll be looking through that, and I'll be in contact with you either this week or next week. And we're going to continue this over for 2 weeks just to make sure we can talk about that discovery.
Okay.
All righty?
All right.
Yeah, that's 2:15, right?
Correct, Your Honor.
Yeah, okay. We got it. Thank you.
I appreciate that, Your Honor.
All righty.
Take care.
What now? She's not a state inmate. Robert Shirley.
Hey, Josh, how long are you gonna need, to talk to him about that offer?
I talked to him about it between court, but I got to present a counter offer to you. So, if we can go out like 2 or 3, if we can go out 2 or 3 weeks.
It's fine with me.
Okay.
How long?
Let's put it on the 22nd, Your Honor. I've been, Commonwealth has presented us an offer. I presented it to Mr. Shirley. He has presented a counter offer that I need to present to the Commonwealth. So.
There's so many presents in there. It sounded like Christmas, didn't it? $222.
All right. Thank you.
You then, Mr. Shirley. Jesse Turner Jr.
Judge, on this one, I don't know, we have a revocation hearing set for next week, so I don't know if Mr. Berry, we hadn't really talked about recently about resolving it. I know he's got the Monroe County case there. Greg, you don't have anything new, I guess, right?
No, not yet. This case kind of getting bumped to the back burner because of the Monroe County case. So we haven't really sat down yet and come up with a counter offer on this matter. He's got this motion to revoke his bond set. And he and I have talked about that, and I assume we need to get that dealt with and see where we're going to go from there, Judge.
Yeah.
Well, yeah, it's on for the 9th, and so I will just put this pretrial over there too, and then we'll kind of see how that plays out and where we go from there.
Okay.
Okay.
Yes, sir.
All right, Judge.
Thank you.
All right. Eddie Vibbert? Yeah, I mean that. All right.
Judge, Greg and I have had a discussion about this case. He asked for an offer on the dispossession case, but he's got a pending F case where he's charged with trafficking. In that case, I sent a global offer over to Greg. I don't know if he's discussed that with his client yet or not. He said he, didn't think he would probably take it until he saw the discovery in the trafficking case, which I understand, but went ahead though and, made the global offer.
Yeah, they have, John did send us over an offer for both, to wrap both cases up. But it is a trafficking case. I really don't want to jump too quick without looking at the discovery and see what they've got before I can tell Mr. Vibber whether I think he ought to take the offer or not.
Sure. How
And I
about,
intend on presenting that case, this month to the grand jury.
what I was going to suggest is how about I put this one, Greg, over about 6 weeks, and then that if he gets indicted in the grand jury, that'll probably pop up on February 22nd.
Okay.
And we can get him arraigned on February 22nd and then get his pretrial in that case set same day we set this one. We'll make it like March 15th or March 22nd or something like that.
Okay, that'd work, Judge.
That'll get them both dovetailed,
Okay.
All right.
So what was that date in March?
Yeah, I didn't settle on it. I said the 15th or the 22nd. I guess, just wanting somebody to tell me which one they like better.
15's fine with me, Judge.
Sold.
You got me.
Excuse me, Your Honor, could I get a bond reduction, sir? Until then?
I believe the big kicker was that, if memory serves, you had this case pending when they rolled in there with those trafficking charges, didn't they? Wasn't it?
Yes, sir. Yes, but I didn't know I was indicted at that time, sir. I was never served with no papers. I was
Well-
about to say, honestly.
I understand. It was pending in, as far as you knew, in the district court, wasn't it?
Yep.
Yeah. I was thinking that when we discussed it, there was a great big old bond on that trafficking that wasn't gonna go anywhere. I don't remember, Amy, if you remember what it was, but
5,000, yes, sir.
yeah. I mean, you haven't made that, have you?
No, could I get the 10%, sir, both of them?
No, I don't have anything to do with that one till you get till you get indicted. Until that happens, you're in the district court.
Okay.
Okay?
Yep. Thanks, sir.
All right, thank you.
Judge, I'm Mr. Smith. I did confirm he is a state inmate.
Okay, thanks.
You're welcome.
All right. Shane Wheat. Hello, Mr. Wheat.
Judge, on this case, I'm still working. It's been a little longer than I'd hoped. I'm still working on a counteroffer to present to the Commonwealth, but I've been having difficulty getting hold of a witness that Mr. Wheat wants me to contact before I send the counteroffer. But I think we've got the communication issue straightened out. So if we can put this on for the 15th, I'm hoping that we have everything. Hopefully I'll have a counteroffer by the end of the week to the Commonwealth, and hopefully we can have something close to worked out by then.
Okay. February 15th?
Yes.
All right, Mr. Wheat, we'll see you then. A couple weeks, okay?
All right, appreciate it.
Larry York? Yes. Everybody? That's what I know. We didn't have his file. That was the one that the file had been taken. It had been taken off the docket because they didn't agree to order to. It was still on the docket, but they had left the file out of it. Oh, sorry. All right. Who's got something to tell me about Mr. York? Anybody?
Judge, I appear to be the only one with this microphone not muted.
So ball's in your court then.
I'm sorry, Judge, I don't even have his file with me. I don't know what I did or didn't do here, but I don't have anything on Mr. York. Just now when you.
Well, Greg, I'm in the same boat. The docket I had didn't have his name on the docket. I don't know if I
Yeah, this is one of those human error scenarios. Back in January, we met and we passed his pretrial to today's date. Somehow that escaped. Just the clerk's office didn't get it put on the docket. And then somebody realized it and they added it on an add-on docket. I don't know if the jail noticed it or what, but it was not on the pre-printed docket, even though this is what we said. So, I mean, it's just one of those things. It happens. But
Is this,
to next Monday, I can.
is it 20 CR 395? Is that the case
20
number?
Yeah, exactly.
And I have that in Century John as Mike's case, I think.
No, it's my case.
It is, okay.
Yeah. And for my last note and last time we we're here, said that he would take a counter offer that I'd made to Greg, and I needed to send Greg the revised offer. Do you have that, Greg? Or, I mean,
I can't remember, John. I'll look, if we could put this off.
look and then,
I'll look it
yes,
up
if you got-
and get back with you.
We agreed on, I agreed on 6 years. I agreed on 6 years, 3 on theft out of Cave City, 3 on the theft out of Metcalf, dismissed both PFOs. And Gardner said he'd run them wild for 6. I said I'd take it.
Yeah, I think you're right.
yeah,
about
that's,
I think
that's right.
Yeah, I was gonna tell y'all that my recollection was the last time that we talked, Mr. York said that very same thing. And then I'm not sure he'd been indicted in Metcalf County, so it was gonna take maybe a rocket deal on that one, because I'm not sure he's gotten indicted over there yet.
Oh, can we do a rocket docket? I'd like to get this on done with. You don't get final sentence.
Oh, yeah, I know. You might have to wait till next Monday, though.
Okay, well, hey, Your Honor, remember we discussed me sending my bond money back to the girl who signed my bond? You told me wait till February 1st, said we get it sent back to her today. Is there any way I can get her?
Remember that, but I'll take your word for it. Who does it go to?
It goes to Hannah Parker.
Hannah Parker.
Yeah, it's 679 Beaver Point, Glasgow, Kentucky.
All right, hold the phone here. 679
Yeah, Beaver Point,
Beaver Point.
Glasgow, Kentucky.
All right, sir.
He did bring that up too, Judge. I remember him.
I appreciate it. I'd like to get her money back to her.
And Greg, I looked at my emails. It looks like I sent you an email with the paperwork on the 13th of January. So if you can't locate it, just let me know. I'll resend it.
Okay.
All right, Mr. York, we can, I won't wait till next Monday to do that on the bond. We'll go ahead and get that ball rolling, but
Hey, thank you, Your Honor. I appreciate it.
yeah, let's put this on Monday so that you all can get all your I's dotted and T's crossed and so forth, okay?
All right, man.
All right.
All right.
See you.
Yeah.
Yeah, I just wrote it right there. Ask them if that's enough. All right. Bonnie, I don't have anybody else. Do I have somebody?
They added Brittany Decker this morning.
Oh, good point. Yeah, we thought she was in Hart County and come to find out she had come to Glasgow. Yeah. Brittany Decker.
Judge, I had filed a motion to revoke her pretrial diversion.
I do have her file from this morning. That is Commonwealth's motion to void pretrial diversion. Hearing needs to be scheduled. That hearing can be 2/9, which is a week from tomorrow. Okay.
Is that it?
Yep, that's it. Thank you.
We're appointed on that, correct, Judge?
Yeah, I had Josh down from the last time. I don't know if that's right, but that's what I had down. All right, Bonnie, thanks.
Thanks, Judge.
I want to know if they've done anything.